Philip Hoban, you have been committed for sentence after pleading guilty on the 8th of August of this year to the offence of using threatening, abusive or insulting words or behaviour towards Sarato Sawa with intent to cause her harassment, alarm or distress, and that behaviour was racially or religiously aggravated. There is a further charge which is summary only. The conduct for that charge will be taken into account during these sentencing remarks. James Gettings, on the 14th of August, you pleaded guilty to one offence of using threatening or abusive words or behaviour with intent to cause Sarata Sawo harassment, alarm or distress, which was religiously aggravated. The context of both of your offending is that it arises out of civil unrest in many parts of the United Kingdom. The civil unrest has resulted in groups of protesters gathering in many locations across the country. On occasions there have been clashes, sometimes with opposing protesters, sometimes using violence towards each other, sometimes using violence towards the police, and sometimes towards entirely innocent and unconnected people and their property. We all live in a democratic society, one in which people are entitled to protest peacefully. They are also entitled to express their views, whatever their views may be, but each of those freedoms, to protest and to speak, have limits and boundaries. When a protest moves away from being peaceful towards violence or threats, then it becomes illegal and against the law. When actions become threatening or abusive towards a person's race or religion, they too become illegal and against the law. When speaking to others, what is said must not contravene the law. The law applies to everyone, no matter what colour, race, religion, or political persuasion they are. There is no distinction. The law is colourblind. The law is there to protect everyone in our society, both in terms of their personal safety and in terms of their businesses. It is against that background that both of you involved yourselves in a protest outside Leeds Art Gallery on the Hedgerow on the 3rd of August. You were both members of or joined with a pro-English Defence League group who were chanting and gesticulating in the direction of a counter-protest. Those were demonstrating against, amongst other things, racism and fascism. Your demonstration was against refugees and those seeking asylum in the United Kingdom. Both of your actions are captured on CCTV footage. Philip Hoban, you climbed onto a barrier and started rubbing your lips towards a person of colour. You were standing alongside and in the same group as others who were making similarly racist and insulting gestures, some making monkey noises and gestures. You were a part of that group. You then started to imitate the manner in which Muslim people pray in order to mock and mimic their religion. And at a slightly later time, you were chanting, Allah, Allah, who the is Allah. That is the subject of the summary-only charge, but it provides useful context to your actions. You were one of the leaders of your group of protesters. You were arrested and interviewed. You denied that you were a racist. James Gettings, you were part of the same group. You too decided to make offensive gestures by mimicking and mocking the method of praying of those of the Muslim faith by getting to your knees near to one of the barriers and bowing repeatedly. When arrested and interviewed, you claimed that you'd been praying for your country. That was a lie, and it was an attempt to disassociate yourself from your conduct. You have accepted that your behaviour was despicable. It was. Looked at overall, this was grossly offensive, racist, and religiously insulting language and behaviour. It caused alarm and distress to others. In relation to the charge for which you appear at this court, namely your conduct towards Miss Sarwo, she has provided a victim personal statement informing me and others how she felt and how she continues to feel. To summarise only, she was scared, anxious, traumatised by your behaviour and that of others in your group. She felt like she didn't belong in her home city, the city where she has lived all her life, to the extent that she was scared to go to work for 4 days following this incident. She remains anxious and worried about returning to university and about whether her loss of confidence will have an impact upon her academic performance. Philip Hoban, you are 48 years of age, with many convictions, including Public Order Act offences, as I have already indicated. James Gettings, you are 35 years old, and you also have many convictions. Yours are more recent, and in particular, you have committed Public Order Act offences in 2013 and 2022. This latter conviction included racially threatening, abusive, or insulting words or behaviour causing fear or provocation of violence. What you have done cannot be viewed in isolation. It must be viewed against the background of unrest and disorder in the country. This was your contribution to that disorder, both in this city and nationwide. Your conduct and that of your group was designed to stir up hatred. It took place at a time when the social climate was particularly sensitive. By the 3rd of August, there had been disorder in Southport, Manchester, Hartlepool, Aldershot, London, Liverpool and Sunderland. I must and will follow the sentencing guidelines. Philip Hoban, in terms of culpability, I find that this falls within category A, since it involves the targeting of individuals by a group and it was a sustained incident. It also falls into category 1 for harm, since Miss Sarwo feared serious violence not only that day but also on subsequent days. The starting point for a category 1A offence without the aggravating factor of racial aggravation is a high-level community order with a range of up to 26 weeks imprisonment. Given the context and background of this incident and others around the country, I would have placed this offence at the top of the range. I must now consider the level of racial aggravation involved and apply an appropriate uplift to the sentence in accordance with the guidelines. Being careful not to double count, I find that the promotion of racial tension was the predominant motivation for the offence, and you were associated with a group which was promoting hostility based both on race and religion. In those circumstances, I will increase the starting point that I consider is appropriate. James Gettings, the starting point and range is identical for your offending, save that your behaviour was motivated by the promotion of religious and racial, rather than simply racial hatred. Your behaviour falls into category 1A for the same reasons. There is nothing to choose between you. This was a group activity motivated by similar views during which you behaved in a similar manner. Your positions are both aggravated by your convictions for Public Order Act offending. At the forefront of my mind are the purposes of sentence, which in this case are punishment and deterrence. I turn to your mitigations. You both pleaded guilty at the first opportunity and will receive full credit, that being 1/3. Philip Hoban, you inform me that you are of mixed race. Then you should know better than to make these comments and gestures. You may be aware of the hurt and the distress that they cause. I have read the references submitted on your behalf by those with whom you have a business relationship, from a work colleague and also your family. They speak of a different person to that who climbed on the barriers, abusing and insulting others on the 3rd of August. I accept that at other times you were seeking to calm those around you, that you are remorseful, that you have done charitable acts in the past and have many Asian friends. You understand that you must be punished for your behaviour. You are a family man and have lost your job. In the past, you have assisted the police to catch and convict online child sexual offending predators. In the context of this behaviour, at this time, any personal mitigation is of limited value. James Gettings, you too have pleaded guilty and will receive full credit. You are ashamed of your behaviour and have indicated your remorse. You too are a family man. Would you both stand, please? I turn to sentence. Given the context in which this incident occurred and the nature of your conduct, which was designed to increase racial and religious hatred at a time of heightened social tension, an immediate custodial sentence cannot be avoided. The sentence that I pass has been reduced by 1/3 to reflect your guilty plea. The sentence for each of you is one of 8 months imprisonment. You will serve up to 1/2 of your sentence in custody before you are released on licence. If you fail to abide by the conditions of your licence, you can be returned to prison to serve some or all of the remaining custodial term. I will also make a criminal behaviour order in respect of Philip Hoban. The purpose of such an order is to prevent behaviour which causes harassment, alarm and distress. It may be made upon conviction. I am satisfied so that I am sure that you have engaged in behaviour which caused alarm and distress. I am also satisfied that making the order will help in preventing you engaging in such conduct in the future. The terms of the criminal behaviour order are as follows. You must not congregate in any public place in a group of 2 or more persons in a manner causing or likely to cause any person harassment, alarm or distress, or to fear for their safety. You must not post any messages on social media which may incite racial hatred. Those are the terms of the order. It will last for 5 years. Can I just check, Miss Pearson, please, that there is no similar application for the co-defendant?
There isn't, my lord.
Thank you. The victim surcharge will apply. I will make a collection order. A copy of the order will be provided to you, Mr. Hoban. That will conclude this hearing.